So we had some concerned folks who were worried about whether Project 2025 has an impact on same-sex married couples for estate planning purposes. I'll address that in just a second. I'd like you to imagine, though, that you're helping a friend who's struggling through a what-if scenario that creeps into their lives, and you shared this video, which helped them out greatly. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we're going to help some folks along the way. Now, I am not certain, as I haven't really poured over the 900 pages of think tank stuff in Project 2025, but one good rule of thumb, however, is when it comes to any kind of proposal established by the government, let alone a political kind of affiliated party, is not to worry until the laws are actually finalized. Why I say this is there are typically many changes along the way to anything becoming an actual law. And I say this too, coming from a tax perspective to help all of my clients. These proposals get thrown out there, and at the end of the day, half of the things don't go through, etc. But also in my brief research to answer this question, it seems as if across the board, people who have reviewed the project in a little bit more detail say that the papers don't really propose anything about banning gay marriage, so it shouldn't have a great impact for estate planning purposes on a cursory level. What I would say to everyone, whether gay, straight, married, or not, that expressing your wishes clearly as to whom you want to choose for making either health or financial decisions on your behalf is critical, as well as who will benefit from any assets you leave behind. Any decent estate planning attorney is going to express the people you choose by their name and not just the relationship, to make it explicit, of course. And if you are married, gay, or straight, under current law, your spouse has rights even without a plan, although it's certainly best to specify whom you choose, because it may be your partner, it may not. And we want to make sure we have some backups in case that initial person is not available. Now, on the other hand, if you have a partner and you're unmarried, I would say that it's even more impressed upon you to make sure your wishes are down in writing, because in those circumstances, even though you could have your partner for 50 years, you don't have any legal rights for saying make medical decisions or even being released medical information. And it could default to someone in your family, immediate family, blood relative that you may not even have a relationship with. Who knows? So it's really important that your estate plan is established, that it designates whom you choose to help you during your time of need, or also to follow through with your wishes at your passing, and to have some backups for each of those roles. So reach out to your attorney. If you don't have one, do a little Google research in your area, your state, and talk to one or two attorneys. See who you're comfortable with and have a conversation about what kind of plan you may need. So we hope you've learned something new here today, and that you choose to share could help someone out. Thank you so much, and please take care.